But first, as many Americans enjoyed Labor Day barbecues or ball games, a federal judge was at work, issuing a high-profile order. The judge agreed to appoint a special master to review the documents seized by the FBI during the search of former President Trump's Florida home. Trump's lawyers had asked for a third-party attorney to keep out any privileged materials from the DOJ's investigation, but it's not clear what counts as privilege or who has the right to keep those materials secret. Robert Costa has the latest.
Tonight, the Justice Department is weighing whether to challenge Florida federal judge Eileen Cannon's decision to authorize the appointment of a special master, a ruling that has generated an outcry from some legal experts and criticism from Trump's former attorney general.
I think was wrong, and I think the government should appeal it.
Cannon wrote that Trump faces unquantifiable potential harm if more sensitive information is made public. And for now, federal investigators have been blocked from further reviewing evidence until a special master's work is done. Some former federal prosecutors say it could slow the investigation for weeks or even months.
It's just an extraordinary eyesore of an opinion. And it manifests in a number of places a palpable bias in favor of former President Trump that would never be accorded any other individual who's the subject of the execution of a criminal search warrant.
Judge Cannon, who was appointed by Trump, was confirmed by the Senate days after the 2020 election. Any appeal by the Justice Department would likely be heard by the 11th Circuit Court of Appeals, where court watchers note 6 of the 11 active judges are also Trump appointees.
They may be in a more hostile Court of Appeals landscape where the risk of an more significant adverse opinion is greater.
If a special master is appointed, the choice would likely need a high-level security clearance given the sensitivity of the documents.
They can't just ship them by FedEx or deliver them to the special master's office. These will only be able to be reviewed in a secured compartmentalized information facility.
And tonight, according to a person close to the Trump legal team, Trump's lawyers now favor a retired judge to be the special master, and they are coming up with a short list of names. They will then begin to quietly reach out to some of them to see their availability ahead of Friday's deadline. John.
Robert Costa in Washington, thank you. For more on this, I want to bring in David Weinstein from Miami. He's a partner with the Jones Walker law firm and a former federal prosecutor. David, let's start with the question of what is privileged. So the Trump team is claiming attorney-client privilege and executive privilege. Gauge both of those for us. Can a former president assert those privileges, and what would they do in terms of these documents that have been taken?
Well, John, let's start with the easier question here. The attorney-client privilege materials. You don't have to be a former president to have a privileged relationship with your attorney, but you have to have communications with an attorney in furtherance of legal representation. So if the former president can prove that a particular document that was seized was one in which he was communicating with his attorney about matters of legal representation, then that would be privileged. But I'm hard-pressed to find out how a classified or top-secret document would be encompassed within that privilege. So moving to the harder question, executive privilege, there's been some dispute as to whether or not a former president still can assert the executive privilege or whether that privilege remains with the incumbent president. And in this particular incident, the incumbent president has already communicated to the people at the National Archives and the archivist that he is not allowing the incumbent president to assert that privilege. So it's really a threshold question, and one that Judge Cannon sort of glossed over in an effort to say, well, I'm not sure whether the former president can assert that privilege, but I'm going to give him a chance to do so.
And by doing so, effectively, implicit allowing the special master to go forward is the belief that this privilege exists? Is that essentially what you're saying?
There's an argument that it does. Certainly the government has cited to a number of legal opinions, including the opinion issued against former President Nixon during the White House investigation, and some recent opinions that have gone up through the District Court of Appeals and up to the Supreme Court that talk about the, again, assertion by a former incumbent president, a former president, is one that no longer remains with him. And in fact, some of these recent decisions have said it have not. Judge Cannon took issue with the government's interpretation of those decisions and said that they were misplaced. And that was part of the reason why she's given the former president an opportunity to have a special master take a look at some of these documents.
So now I want to ask you two questions. One is about what a special master can do. But before we get to that, what is the Department of Justice prohibited from doing as a result of this order?
What they're prohibited from doing, John, is that they cannot look at the moment at any of the documents that were seized during the execution of this search warrant at Mar-a-Lago, with the exception of a separate review that's being undertaken by the National Security Section with regard to these secret and top secret documents. They can't look at any of the evidence that was seized. They can't use it during their presentation to the grand jury. They cannot use it to further their investigation. But that doesn't stop the investigation itself. There are other avenues and methods and witnesses that they can talk to, other items that this grand jury can subpoena, other records, and certainly there is more that can be done by the department. They just can't use any of the evidence that was seized for the moment.
And just briefly, David, what is the special master's word final in this?
No, not at all. The special master, according to the rules in civil cases, which is what this is, will issue an order that is then reviewed and looked at by the parties and ultimately by the judge who's presiding over this, who will decide whether or not the special master's ruling is a correct one.
All right, David Weinstein, thanks so much for helping us untangle that.
You're welcome.
CBS News national security contributor Michael Morell is here with me now. He is also the former acting and deputy director of the CIA. Mike, I'm smiling because throughout this whole story, I've thought, Mike knows what it means to have these documents in his hands. So when we're talking about top secret, can you give us a sense of what that means? We know the classification is really important, but what does it mean in real terms?
So inside the government, there's 3 levels of classification: confidential, secret, top secret. The difference between those is the government's judgment on the degree of damage that would be done if those got into the hands of our adversaries. For top secret, the definition is exceptionally grave damage.
People will die.
Potentially, people can die, sources, CIA sources, or technical collection methods can be turned off, right, if the adversary knows what they are.
So we have visibility into some adversaries that is highly unique. We know what they're doing that they shouldn't be doing.
Right.
And you're saying that can be turned off.
So for a chunk of these documents, they have special markings. One of the special markings is HCS, Human Control System. That is information derived from CIA spies, right? Individuals overseas who are spying for the United States of America, who might be in meetings, who might be passing us information about what happened in that meeting. There's another marking, SI, called Special Intelligence. That's information collected by the National Security Agency, a variety of different technical ways: intercepting phone calls, intercepting emails, getting inside of a computer and pulling information out, right? So if an adversary gets that information, they might be able to figure out who the source is, go arrest them, possibly kill them, or in the case of NSA, find out what the method is and turn that off.
The judge said the Office of the Director of National Intelligence could keep going through looking at whether there'd been any damage done. So what does that entail, and what conclusion might the DNI come up with?
So she will put together a task force of people who understand these issues and these documents and classifications and sources and methods, and they will go through all of the documents, and they will essentially ask themselves, John, if an adversary had this, what could they figure out? What could they learn from this information? And because of that, what source is at risk? A person possibly, or what method is at risk, right? A technical collection program.
I want to ask you some national security questions off of this, but one last one. If it becomes the case that it's kind of easy for political reasons to have this kind of information flowing around, how does that, distinct from these specific documents, what does that do in your mind to the retention effort or the way these kinds of documents are handled?
So within the 2 White Houses that I worked most closely with, so the Bush administration and the Obama administration, so a total of 16 years, significant interaction on my part, there was great care taken for classified documents in those White Houses. the secretary of the National Security Council and the secretary that the president has keeps track, or kept track in those two administrations, who had what document, when did they get it, when was it given back, and if it wasn't given back, at the end of the administration, you go looking for it. So very rigorous process in those two administrations. Doesn't appear that that happened in this case.
Finally, it was reported that Russia is buying artillery from North Korea. That's one thing. And Russia is doing joint military exercises with China. Is there a kind of military wing to the autocrats club that's being created here?
So in the case of North Korea, this is a marriage of convenience. The Russians need weapons. They can't make the weapons themselves because they can't get the parts because of the sanctions. North Korea has a lot of artillery. North Korea needs money. Right. What does Russia have? A lot of money from the oil sales. So that's a marriage made in heaven. In the case of China, it's a little bit more complicated. They've had joint military exercises now for a number of years. This is just one of those. This has a lot more attention because of Ukraine. I'd say that Russians and Chinese have two things in common. One's a major energy exporter, Russia, and one's a major energy importer, China, right? That's an important relationship. But the bigger relationship here is they both have the same goal vis-a-vis the United States, to weaken us and weaken us everywhere in the world. And it's those two things that define this relationship at the end of the day. But one of the interesting things about the relationship is that Xi Jinping sees himself as the senior partner. And he sees Putin as the junior partner, and that must drive Putin out of his mind.
Yes. Fascinating. Mike Morell, thanks so much for being with us.
Great to be with you on your first show.